Welcome back to The Legal Brief, the show where we make it easy for you to understand gun laws here in the US. I'm your host, Adam Kraut, and today we're talking about the newly minted law in Oregon that might allow the police to confiscate your guns.
Rand CLP offers an entire lineup of non-toxic cleaners and lubes for the discerning shooter. You can use their bore and bolt to clean up carbon, fouling, or rust, and then follow it up with their CLP, or for hot and heavy applications, the hog grease, for before, during, and after the range. Find out what the nano-infused bio-friendly lineup from Rand CLP is all about over at randclp.com.
Look guys, I need your help. So often I read comments from people exclaiming their negative feelings about the NRA, but the only way to change that is to get someone on the board of directors that can help your voice be heard. If you're an NRA Life member, an annual member for the past 5 years, or know someone who is, head on over to adamkraut.com to get a petition to place me on the ballot for the NRA Board of Directors in 2018. It's not very difficult. All I'm asking for is a minute of your time. If you guys would help me out, that would be massive. Did he say confiscation? Yeah, he said confiscation. Earlier in August, Oregon Governor Kate Brown signed Senate Bill 719 into law. The new law allows the police or a member of a subject's family or household to file an extreme risk protection order petition with the court, which could lead to an order prohibiting firearms possession if it is believed they pose an imminent risk to themselves or others. And I'm sure none of you would be shocked, but the bill was only supported by one Republican in the Senate and none in the House. So what exactly does the new law do? As I said a moment ago, it allows for a police officer or member of the subject's family or household to file a petition with the court when they believe a person will pose an imminent risk to themselves or others. After a petition has been filed, the court must hear the petition the same day or the next judicial business day. Those seeking a petition must write a sworn statement or give a sworn oral statement from themselves or any witness. I swear. The court will look to 7 factors when considering a petition before it. These include 1. History of suicide threats, attempts of suicide, or acts of violence by the person the petition is being sought against towards other people. 2. History of use, attempted use, or threatened force. 3. Previous convictions for a litany of things including driving under the influence. 4. Evidence of recent use of a controlled substance. 5. Violation of a previous restraining order. 6. This is the most troubling one to me. Evidence of an acquisition or attempted acquisition of a deadly weapon. And 7. Additional evidence the court considers reliable, including a statement by the person against whom the petition is sought. Let's talk about why number 6 is so troubling. The new law defines the term deadly weapon as any instrument, article, or substance specifically designed for and presently capable of causing death or serious physical injury, or a firearm whether loaded or unloaded. Essentially, it would appear that if a person filed a petition and stated that you recently acquired a firearm, you'd be at risk of having one of these petitions granted against you and losing your guns. Worse yet, the initial hearing is held ex parte, meaning that the accused isn't present and has no opportunity to present a defense against the accuser. Now, the law does state the court shall only issue an order if it finds by clear and convincing evidence that the person presents a risk of suicide or causing physical injury to another in the near future. And for those of you that don't know, the clear and convincing evidence standard is a medium burden. It's less than beyond a reasonable doubt, which is required in things like murder, but more than a preponderance of the evidence, which is a very low standard. Those who have an order issued against them can request a hearing to challenge that finding. I believe the saying is guilty until proven innocent, right? However, the law also states that an order issued shall prohibit the individual who it was issued against from having in their custody or control, owning, purchasing, possessing, or receiving, or attempting to purchase or receive a deadly weapon. An individual has 24 hours to surrender all deadly weapons in their custody or control to law enforcement, a third party, or a gun dealer. Which begs the question then, where do I put all these kitchen knives that I have? Do they fall into this nonsense? Anyway, additionally, if they have a concealed carry permit, they have to surrender that within 24 hours as well. After the order is served on a person, they have 30 days to appeal it. A hearing must be held within 21 days of an appeal, which means that a person might very well have to surrender their firearms prior to a hearing. If a person fails to appeal the order within that time frame, the order is confirmed by operation of law for a period of 1 year unless it's terminated earlier. Again, this raises a lot of due process concerns as you now have a person who's being denied a constitutional right due to an ex parte hearing with no guarantee of a hearing for a period of up to 21 days after they appealed the decision. This means that if a person does not appeal the order until the last minute and a hearing isn't granted until day 21, they could potentially go up to nearly 2 months without possession of their firearms, having had no hearing. At the hearing itself, the petitioner or the person seeking the order has to again prove by the clear and convincing evidence that the other person poses a threat. If they're successful, the order remains in effect for that 1-year period. If they're not, the court must immediately terminate the order. The law also allows for a person to request that an order terminate early and enables a requester of an order to renew one that was currently issued 90 days prior to the expiration of the previous one, which again requires another hearing. Once an order has been terminated, if the deadly weapon is a firearm, they are returned to the individual after a background check has been conducted. As always, laws like this cause grave concern for the due process rights of those accused. In essence, a person could be accused of being a threat and be denied their Second Amendment rights while the courts sort it out. The only small sliver of silver lining in this is that a person who knowingly files a false petition against someone is guilty of a Class A misdemeanor. Time will tell whether or not they actually get prosecuted. If you're concerned about the rights of your fellow gun owners in Oregon, you need to share this video and let people know about this law. Don't forget to hit that like button, and if you aren't subscribed already, you better make that happen. Be sure to ring that bell so you don't miss an episode. Check out my website, adamkraut.com, and be sure to grab a petition. And as always, thanks for watching.
The shirts worn in today's episode of The Legal Brief have been provided by Patriot Patch. Click the link in the description to learn more.